Chapter 4 on Merger and Extinguishment 36 and 37 Vict. C. 66, Sect. 25, Subsect. 4. There shall not, after the commencement of this Act, i.e. November 1875, be any merger by operation of law only of any estate, the beneficial interest in which would not be deemed to be merged or extinguished in equity. A. Any merger, or rather, any legal merger. Legal merger, or merger at law, is the annihilation of one vested legal estate, not necessarily in land, in another greater vested legal estate in the same property, by reason of their meeting in one and the same person, without any intervening estate. By greatness of an estate is meant either its quantity or quality. Quantity relates to its duration or degree. Quality relates to its nature or incidence, e.g., whether it is in possession or in reversion. The latter is greater in quality than the former, though it be less in quantity. The estates may so meet, I. by act of the party, 1. in the same right, 2. in a different right, auto droit. Auto droit comprises the relation of husband and wife, executor and administrator, and a corporate, as distinguished from an individual, capacity. But the relation of trustee and cestuique trust is not one of auto droit. 2. By act, or operation, of law, but in the same right only. B. By operation of law only. These words seem to confine the subsection to the cases secondly above named, viz. estates meeting in the same right by act of law, though it does not appear why the subsection is so limited. All other cases of merger at law, however, not covered by this subsection, in which there is no merger in equity, are covered by sect. 11. It will be necessary, therefore, to consider them also. C. Of any estate. This would seem to exclude from the subsection the doctrine of merger as applied to charges, or as it concerns mortgages and their priorities, but as those cases are also covered by subsect. 11. Where there is any variance between the rules of law and equity upon them, they also are here to be considered. D. The beneficial interest in which would not be deemed to be merged or extinguished in equity. Extinguishment at law is, as distinguished from merger at law, the annihilation of a collateral subject, right or interest in the estate out of which it is derived. And there may be extinguishment at law by operation of law, e.g., where a rent charge in fee devolves upon the tenant in fee of the inheritance on which it is charged. Such extinguishment at law is not within this subsection, but will, where there is a variance between the rules of law and equity, be within subsect. 11. The definition above given of legal extinguishment, or extinguishment at law, seems to apply to extinguishment in equity also. Where, then, and in what cases, is there no merger or extinguishment in equity of the beneficial interest in an estate? For that is the test, to which all questions of merger at law by operation of law only are to be henceforth brought. The non-intervention of an intermediate estate, so essential in order to effect merger at law, is immaterial in equity. There, estates without any intervening estate may, on the one hand, meet without merging, whilst, on the other, they may meet and merge, though there be an intervening estate. I. Estates meeting in the same right. 1. Where one having a particular legal estate, coupled with a trust, subsequently acquires a legal estate in remainder of equal or greater extent, or rather quantity, either through his own act, e.g., trustee of a term purchase is the inheritance, or by act or operation of law, e.g., the freehold descends on, or is devised to, the trustee of a term. A devise not being an act of the party, at least of the devisee, where one has the legal fee in his own name, and for his own benefit, and a particular legal estate is subsequently acquired by him as trustee, either by his own act, e.g., heir or devisee in fee has a term assigned to him in trust, or devolves upon him in trust, e.g., devisee in fee has assented to the bequest of a trust term of which he is executor, where the equitable fee and a particular legal estate meet in the same person, e.g., to a. in fee in trust for b. in fee, who has a legal term on, where the legal fee and a particular equitable estate meet in the same person, e.g., a legal term in a. in trust for b, who acquires the immediate legal reversion in fee, whether by descent or conveyance, whether beneficially or as trustee. In the two last examples there was no merger at law, because it did not recognize equitable estates, therefore there is no conflict. Now that it will recognize those estates under Sect. 24 of the Judicature Act, 1873, the equitable rule, it is presumed, will still remain. 5. Trust of a fund in court for husband for life, then for wife for life, then for son absolutely. Husband and son assign their interests to wife, in order that, her estate being converted into one in possession, she may assign it to the son. This is no merger at law of the wife as reversion, being an assignment of an equitable chosen action, but had it been, equity would not permit it. 2. Estates meeting in different rights. 1. Trustee of term takes to wife the freeholder. 2. Freeholder takes to wife the trustee of a term. 3. Freeholder leases, and becomes the executor or administrator of lessee. 4. Executor or administrator of a term becomes the devisee or heir. There is no merger in the above cases even at law, the estates meeting by act, not of the party, but of the law, e.g. the marriage, probate, and c. Therefore this subsection does not apply, nor does subsect. 11. For there is no conflict between the rules of law and equity, semble, following here the law. 5. Executor or administrator of term purchases the inheritance. Here there was a merger at law, though not by operation of law, but not in equity, henceforth the equitable rule will prevail by Sect. 11. Merger, or, more properly, extinguishment, of charge in estate. A charge will sometimes be merged at law, which will be preserved in equity, and will sometimes merge in equity, when it will subsist at law. Here is a twofold conflict, which will henceforth be removed by adopting, by virtue of sect. 11. The equitable doctrine in all cases. It becomes necessary, therefore, only to consider that doctrine. The cases where there is no conflict, i.e., in which both at law and in equity there will either be merger or no merger, are not within our subject. Mr. Tudor divides the cases into 1. Those where the owner of the estate becomes owner of the charge, and 2. Where the owner of the charge becomes owner of the estate. The distinction, apparently, is one of the order of time. The guiding equitable principles are, that where the qualities of debtor and creditor are united, there arises a confusion of rights, which extinguishes the two credits, that mergers are odious, and never allowed except for special reasons, that in all cases of a charge merging in equity, it must be perfectly indifferent to the party in whom the interests have united whether the charge should, or should not subsist, and that the test of merger or no merger is the intention of the owner of the charge at the time of acquiring it, the presumption of which intention is different according to the nature of his interest in the estate. It is necessary, therefore, to consider the equitable rule with reference to that difference. Where the estate, even of a lunatic, is in fee simple, or a tenancy entail in possession, for his power of acquiring the fee simple places him on the same footing. Rule in equity. The charge will merge, for it is generally no use to one to have a charge on his own estate, though secured by a legal term, and so not merging at law. Exception to rule. Unless an intention, express or implied, that it should not merge, be shown. Where no express intention is proved, the court considers what is most advantageous to the owner. 2. Where the estate is for life, with or without an ulterior remainder in fee, or a tenancy entail in remainder, or restrained from alienation, or a tenancy, subject to be defeated by an executory devise. Rule in equity. The presumption is, that the party paying off the charge paid it for his own benefit, because, at least in the case of a tenant for life, of the scantiness of his estate though he has not kept it alive at law by assigning it to a trustee. The presumption, however, hardly, if at all, arises on paying off a bond. Exceptions to rule. Unless it is a matter of indifference to him, whether it is kept alive or not, a distinction is admitted to exist, in the case of a tenant entail in remainder, who has become entitled in possession, between the case where he pays off the charge himself, and where he becomes entitled to it without any act on his part. In the latter case it would be indifferent to him whether the charge sinks or not, and so the presumption in favor of merger is increased. Unless the intent be shown, as it may be, to exonerate the inheritance by the payment. The burden of this proof does not lie upon the limited owner. F. The charge considered as regards its priority over other encumbrances. Rule in equity. Prima facie, a debt charged on an estate and paid off by the purchaser of such an estate, whether he be the mortgagee owner of the debt or not, merges as against other encumbrances of whom he had notice, and to keep it alive, so as to acquire priority over them, he should, in prudence, have it assigned to a trustee for himself, though the intent to do so without an assignment is sufficient. And the fact that merger would give priority to other charges, raises a presumption sufficient to rebut merger. And so if the purchaser be the mortgagor himself, buying from the mortgagee, who sells under his power of sale, and paying it off with the purchase money, he pays it off for the benefit of the inheritance, and consequently of those who at that time have an interest therein. Exceptions to rule. The extinguishment will not preclude the mortgagee purchaser from setting off a debt, due to him from the subsequent encumbrancer, against the charge of the latter. And the intention, of all parties joining in a new mortgage, to preserve the old debt will prevent its extinguishment. So if the mortgagee be the devisee of the equity of redemption, the charge will not merge. And the same principle seems to apply where the equity of redemption descends on the mortgagee. G. The merger of securities. The law of the merger of one security in another of a higher nature, as well as the exemptions from such merger, appear to be the same at law and in equity. Such cases, therefore, are not within subsect 11 of sect 25, and not being cases of estates, are not within this subsection. They are, therefore, not within the scope of this work.